So hello everyone and welcome back again in part number 16 of the Bear Act. And in this part we will cover from article 101 to 105. In this video I have taken only 5 important articles because these article contains many clauses as well. So it will take a lot of time to discuss all these article one by one. Okay. Now, in my last video, I have discussed till the article number 100. And article number 100 was about the voting in the house or the simple quorum. Okay, so quorum should be 1 by 10th of the total strength of that particular house to carry out the proceeding or to carry out the transactions of the business of the houses. It means either Lok Sabha or Rajya Sabha, Council of State or House of the People. Okay, now let's move forward and discuss article number 101, and this article is basically about the vacation of the seats. In my earlier videos I have talked about the vacation of the seats of the office bearer of the Rajya Sabha and the Lok Sabha. That means chairperson, vice chairperson, I mean deputy chairperson, and speaker, and DY speaker, deputy speaker. But in this article we will talk about the MP or the MLA when their seat can be vacant. That means it is some sort of the disqualification of the members, right? Now article 101 is about the vacation of seats, and as I have already told you, contained various provision or the clauses, right? So clause 1 says that let's suppose if a person is a member of the both houses of the parliament, that means a member is chosen to the Rajya Sabha as well and to the Lok Sabha as well. Don't think that person is only hold the membership of one house, not both. As we all aware that one value has one vote. That means one vote, one person, one value, right? So how can an MP become a member of the both the houses, Rajya Sabha as well as Lok Sabha? No. Then what happened in this case? If a person is chosen to Rajya Sabha and the Lok Sabha as well, so their seat in one house shall become vacant according to provisions made by the law, made under the law by the Parliament of India. That means law-making power regarding the vacation of the seats if a member is chosen to both the houses is completely lies with the Parliament. So Parliament has the authority to draft the laws. Okay, so a person can't be continue as a member of the both Lok Sabha and Rajya Sabha at the same time. He has or she has to vacate his seat in either house of the Parliament. Clear? And that law will be made by the Parliament. Clear? So clause 1. Now clause 2. Clause 2 says that let's suppose if a person become a member of the Parliament in the state legislature as well. That means a member own the seats from the constituencies of the Lok Sabha, the Parliament, and apart from that of the state legislature as well. That means he is MP and MLA. If a person chosen the members of the either house of the Parliament and apart from this or in addition to a member of the state legislature as well, that means MLA, then if a person is chosen as a member of both, then their seats in the Parliament become vacant. But there is a condition as well, unless they have resigned their seat in the state legislature within the prescribed time. That means if you are chosen as a MP and the MLA as well, right? Now if you will not take any action, that means from its own, if you will not vacate the seat of the state legislature, then automatically, I mean by the law, your seat in the Parliament, that means as an MP, will vacant. Okay, so if you will not take any decision to vacate the seat of the legislature, state legislature, then your seat in the Parliament will vacant. Clear? So this was clause 2, clear, of the article 101. So a person can't be simultaneously an MLA, MP or MLC, and if elected to both, they must give up one according to the prescribed rule. Simple meaning, if you are not vacating his or her seat from the state legislature, then your seat from the Parliament will vacant. Clear? Clause 3. So clause 1 about the MPs of the Parliament only, that is both the houses of Parliament. In clause 2 was about one Parliament and other is state legislature. Now clause 3. Clause 3 is that if a member of either house of the Parliament, That means if you are a member of either house, whether if you are from a member of the Lok Sabha, if you are a member of the Rajya Sabha, become subject to any of the disqualification mentioned clause 1, that means MPs in the both houses, and clause 2, that means MP plus MLA of Article 102, or resign their seat by writing address to the chairman or the speaker as the case may be, and the resignation is accepted by the chairman or speaker, their seat shall thereupon become vacant. That simple meaning that clause 3 of the Article 101 contains that if a member of the either house of parliament and they become a subject to the disqualification under Article 101 clause 1 and 2, or they can even resign their seat by addressing to the chairman or the speaker, that means presiding officer of the respective house. Okay, then also their seat can be vacant. So an MP seat becomes vacant if two clause of 102 101, am I discussing 102 or 101? Let me get it. 101. Okay, I will discuss 102 later. So or MP resign by submitting his resignation to the presiding officer, that is mentioned in the constitution. If disqualification or simply accepted as a resignation, then seat will become vacant. Okay, clause 4, this is the very important provision because UPSC might ask a question from this domain, because this clause contain a definite time period, and if for a period of 60 days a member of either house is absent from all the meetings of the house without the permission of the house may declare his seat as a vacant. Now suppose you are a member of the parliament. It is true in the case of the state legislature as well. So if you are a member of the parliament and you are absent from the attending the procedure or proceeding of the parliament of the either house continuously 60 days without the permission of the house or without the informing the house, then your seat may be considered as a vacant. This is important. So 60 days period is very important. If you are continuously absent since the 60 days, past 60 days without informing the house, then your seat can become or considered as a vacant. Okay, so this was clause 4 of the Article 101. So 1, MP of the both house, you have to vacant one. To clause 2, that means if you are a member of parliament and in addition to legislature, then you have to vacant the seat of 1. If you will take the decision to vacant his seat in the state legislature, then your seat in the parliament will be safe. Otherwise, if you will not take any kind of decision, that means in which house you want to vacant your seat, you want to give up your seat, then your seat in the parliament will be considered as a vacant. Article 3, 102 I am going to discuss. Apart from this, if you will submit resignation to the presiding officer, right, then your seat can also be vacant. In clause 4 I have discussed here that if you are absent continuously 60 days without informing the house, then also your seat can be considered as a vacant. So these are 4 clauses of 101 article. I have discussed it in very detail. If you have any doubt, always welcome in the comment section, and also I like your feedback as well. So if an MP remains absent from all sitting for 60 days without the house permission, then the house will consider your seat as a vacant. Okay, but it is not automatic. That means this procedure is not simple, right? You just can't disqualify any people elected member, right? So it is not automatic, but yes, this provision is under 101 clause 4 of the Indian Constitution. Okay, 60 days is mentioned. That why Bear Act is more important for you. Article number 102, and that I have mentioned in the clause 3 of 101. Clear? So disqualification for the membership. Clause 1 says that a person shall be disqualified for being chosen as and for being a member of either house of the parliament, and it has various sub clauses as well. That means how a member can be disqualified. So let's suppose if a member is under the working as a organization or any, you can say, office that comes under the office of profit under the government of India or the government of any state as well, other than an office declared by parliament law not to disqualify its holder. That means if you are a governor, if you are a president, if you are a vice president, if you are MP, if you are MLA, these offices are not under the office of profit, right? But there are some other offices that are under the office of profit, and if you are fall under that category, then you will be disqualified for the membership of the house of the parliament or even state legislature as well. Okay, so if an MP hold an office of profit under the government of India or the government of state as well, they may be disqualified, but parliament can declare certain offices not to cause disqualification, and it is included in RPA Act of 1950 and 1951, Representation People Act, right? 1B, that means article 102 1B. Okay, if he is unsound mind and stands so declared by a competent court. So first was that of about the office of profit, and second is unsound mind. So if UPSC ask the question that among the following grounds that are mentioned in the constitution, not any statutory act, a statutory law, among the following ground mentioned in the constitution of India under which a member can be disqualified, then you have to remember the grounds that are mentioned specifically, exclusively in the constitution of India. Clear? So if a person can be disqualified if a competent court, focus on the word or phrase competent court. Okay, so the court also should be competent one, has legally declared them of unsound mind, then that person cease to be a, or you can simply say can be disqualified from the membership of the parliament. 1C, undischarged solvent. So one was about the I have discussed it earlier about the office of profit, and second was about the unsound mind, and the third is undischarged insolvent. That means a person who has been declared insolvent and has not yet been legally discharged from that status can be also become a ground for their disqualification. So undischarged solvent, insolvent means insolvency has not been legally cleared yet. Clear? 1D, if he is not a citizen of India, okay, or has voluntarily acquired the citizen of the foreign state. As you all know that India does not allow dual citizenship. If you will acquire the citizenship of any foreign state, at that moment of time you will be ceased to be a Indian citizen or citizens of the India. So for becoming a members of the house or even state legislature, you must be an Indian citizen. As soon as you cease to be a member, you cease to be a citizen of India, you also cease to be a member of the house as well, or under any acknowledgements, obligations or adherence to the foreign state. That means you are spying for any foreign state. Okay, so a person can be disqualified if they are not an Indian citizen, voluntarily become a citizen of another country, or accept alliance to the foreign state. So I have under discussed four ground. There are some other as well. 1E, if he is so disqualified by under any law that made by the parliament, like RP Act I have discussed earlier, and also 10th schedule added by amendment in 2010, I think. Okay, so parliament even can create additional disqualification through the law. It is not under the state legislature the power to make a law on the grounds that the members can be disqualified on that ground. It completely lies with the Parliament of India. Clear? So 5 ground, 4 already mentioned in the Constitution: office of profit, unsound mind, undischarged solvent, and citizen of India. And the other, a parliament think they can make a law, other grounds as well. Clear? So now remember Article 101 Clause 3. Clear? So disqualification or resignation. So these are two main provisions that are included in the Constitution of India. Please ignore background noise. Clear? Now clause 1 I have discussed 5 parts. Clear? Clause 2. Clause 2 says that suppose if a person shall be disqualified for being a member of either House of Parliament, if he is so disqualified under 10th schedule, 85th Constitutional Amendment Act, not 2010. Okay, so I have discussed so many provisions under which a member can be disqualified from a membership of the houses, but there are some other grounds as well, and the ground is 10th schedule. If you are disqualified under 10th schedule, then you will be ceased to be a member of the House of the Parliament. Clear? Now this is called anti-defection law. If an MP is disqualified under the 10th schedule, if an MP is disqualified under 10th schedule, they will lose eligibility to continue as an MP. Clear? So one more important thing, that 10th schedule deals with the anti-defection law. Clear? 10th schedule deals with the anti-defection law. Clear? So these are the grounds that are mentioned under the constitution, in the constitution, under various article, through which a person can be disqualified. Clear? Now one thing that need a correction, it's not 85, I'm sorry for this, it is about 50 seconds, sorry 52nd Constitutional Amendment Act of 1985, okay, of 1985, during the Rajiv Gandhi tenure. Clear? So Article 101 was about the vacation of the seats, under which condition seats can be vacant, and 102 was about the disqualification. Clear? Now coming to 103, decision on the question as to disqualification of a member. That means who will take the ultimate decision if a member disqualified. So its clause 1 says that if any question arises as to whether a member of either house has become subject to any of the disqualification mentioned in clause 1 of the article 102. That means I have discussed 4 ground. The question shall be referred to the decision of the president, and his decision shall be final. Let me simplify it. I have discussed various ground by which a member cease to be exist as a members of the parliament, or he or she will disqualify for the house, right? But who will take ultimate decision in normal circumstances that I have discussed in article number 102 clause 1, various clauses. That means the grounds that I have discussed are basically office of profit, unsound mind, undischarged solvent, and the one last was it was about the Indian citizenship or citizenship of India. On these grounds, the ultimate authority to take a decision or the final is lies with the president. But as you will see, in the case of 10th schedule disqualification, the ultimate decision lies with the presiding officer, or more specifically speaker. Okay, so you must know the difference, that who has the ultimate decision or who has the final authority to disqualify the members under the various provision. Excluding 10th schedule, it is in the course of the president. Clear? So there is a question about whether an MP has incurred an article 102 clause 1 disqualification, then it is decided by the president. But before giving any decision on such ground, clause 2 of article 103, the president shall obtain the opinion of the election commission and shall act according to such opinion. It is mentioned in the constitution under article 103 clause 1 that president has to seek the opinion of the election commission before declaring that this member is disqualified under article 102 clause 1. Clear? So president can't decide independently. He has to seek, or she has to seek the permission of the election commission. And if election commission thinks that yes, this member should be disqualified, then president will disqualify that member, because ultimately who has the responsibility to let the subscribe the oath to the members of the parliament? It is person authorized by president or the president itself, right? So if president elect them, then president disqualify them. But this is not true under the 10th schedule. Clear? So election commission opinion is binding on the president on this matter. This is about the article 103, who has the ultimate decision if a members of the parliament disqualified under article 102 clause 1 of the Indian constitution. I'm not talking about 10th schedule. No. That was under article 102 clause 3. Clear? Now 104. This is very, very important article. Clear? So article 103, only 2 clause 1 and clause 2. Clear? 1 president, in clause 2 president has to seek the opinion of the election commission. Now clause 104. Now just tell me one important thing, and the important thing is that if a member do not subscribe the oath to the office, then can he be liable to sit in the proceeding of the house or take part in the proceeding of the house, can speak? No. This is not allowed under the Constitution of India. That member will be penalized 500 rupees per day, and I am going to discuss it. So if a member without subscribing oath and they are sitting in the parliament and they are taking the part in the proceeding of the parliament, then what will happen? That penalty will be imposed on that member. So if a person sits or votes as a member of either house of the parliament before making and subscribing the required oath or affirmation under article 99, That means Article 99 mention that it is compulsory for the member to take or to subscribe the oath or affirmation, or knowing that they are not qualified, even if you know that you are not qualified to become a member of the houses, and even if you are sitting, if you are taking part in the parliamentary proceeding, then you will be liable to a penalty of 500 for each day on which they sit at the oath. That means yes, penalty is mentioned under Article 104. Clear? So this is very important that you should not sit or you should not take part in the proceeding of the parliament unless you don't subscribe oath or affirmation under Article 99. So an MP can't legally participate in the parliament if he has not subscribed the oath or taken the oath, or if the person knows that he is not qualified to become a member, he is not qualified, he or she is not qualified to sit in the proceeding of the parliament, then 500 rupees per day you will be penalized. Clear? For each day they say. And the last article for today, and most important one article, and it is in news and continuously this article keeps itself in the news, right? So this article about the powers, privileges and immunities of the parliament and its member. So parliament means collectively and members means individually. So there are certain kind of privileges, powers that are given to the parliament as a collectively. That means whatever will be discussed in the parliament, that should not be challenged in any court of law. That is a collective power of the parliament, right? And also individual members as well. Clear? So clause 1, subject to the provision of this constitution and the rules and standing order regulating the procedure of the parliament, there shall be a freedom of speech in the parliament. Now just tell me, which article of the Indian constitution granted freedom of speech in the parliament to the members of the house? That is 105 clause 1. So MPs have a freedom to speak in the parliament, but that should be subject to the constitution and the parliamentary rules. Clear? So freedom of speech in the parliament, but your freedom of speech also is not absolute in terms, like absolute in sense, because there are certain parliamentary proceeding rules available to both the houses, Lok Sabha as well and the Rajya Sabha as well. And apart from this, constitution also provides some provision that you should keep in mind while you are speaking in the parliament. So this was about the 105 clause 1 about the freedom of speech. 105 clause 2, no members of the parliament shall be liable to any proceeding in any court in respect of anything said or any oath given by him in the parliament or any committee thereof. That means if you are a member of the houses or if you are a member of the committee, whatever you will say in the parliamentary proceeding, you are not liable to give reason, to give answer in any court of the India. No person shall be liable in respect of the publication by or under the authority of either house or parliament or any report, paper, oaths or proceeding. That means you are free to publish the proceeding, oaths, paper, report, etc. Right? But that should not be in the sense that wrong one. That means you are not manipulating. Clear? If you will manipulating, then you can't publish that. Right? So you can publish the truth, not the any false. Clear? So an MP gets protection. Now it is individual, right? It is individual, and the earlier I have discussed was about the parliament as a collectively. So these distinctions should be keep in mind. So an MP gets protection for what they say in parliament, how they vote in parliament, right? So they can't be taken to court mainly for that parliamentary speech or oath. There is also protection for authorized publication or parliamentary proceeding. Clear? So parliament speech plus oath, constitutional protection has been granted to the MPs. Clear? Clause 3. In other respect, the powers, privileges, immunities of the each house of the parliament and of the members and the committees also, committees of each house, shall be such as may be from time to time be defined by the parliament law until so defined shall be those privileges and immunities. Simple meaning, house and its member and committees immediately before the coming into force of section 15 of the constitution 44th amendment in 1977. Simple meaning that if parliament think that there should be additional privilege or the power that must be or that should be available to the members of the house, then law making power regarding this is lies with the parliament. Clear? Lies with the parliament. But don't think that it should be lies with the state legislature as well for the MLA. No, that power completely lies with the parliament. Parliament will make the laws regarding additional power, privileges or any terms, right? So parliament can make a law defining its privileges and immunities. Until parliament makes such a law, the existing constitutional provision regarding these privileges continues as provided by this clause. That means parliamentary privileges under article 105 may the privileges or the immunities that are provided exclusively under Article 105. That is completely fine. But if Parliament think that there should be additional one, then Parliament will make a law regarding that. So who has the power? Parliament. Clear? Clause 4. The provision of the clause 1, 2, 3 shall be applied to person who, by virtue of the Constitution, have the right to speak in or otherwise to take part in the proceeding of a House of the Parliament or a committee thereof, as they apply to the members of Parliament. That is simple meaning that the protection relating to parliamentary speech or the parliamentary privileges can also apply to certain non-MPs who have a constitutional right to participate in the parliamentary proceeding. That simple mean AG, Attorney General of India. Clear? As you all know, Attorney General of India can become a member of the committee as well. They can take part in the proceeding of the House, but they can't vote, right? They can also speak in the House. So, are the privileges, power, or immunities that are available to the members of the Parliament. But Attorney General, AG is not a member of the Parliament. So, that privilege, power, immunity is also available to AG also. Yes, that's what contained Article 105, Clause 4. Clear? Now let us take a quick revision and then wrap up this class because it almost half hours, not over half hours. So Article 101, vacation of the seats, but when it is about the only vacation of the seats. Article 102, disqualification. I have discussed in clause 1 4 type, right? So the first one was office of profit, second unsound mind, third undischarged solvent, and fourth was citizen. Clear? Or 5, Parliament if think they can make law regarding the grounds upon which members can be disqualified. Clear? 103, President will decide if a member is disqualified under Article 102 of Clause 1, but President has to seek the opinion of the Election Commission as well. Clear? And 104, if you are a member of the House and if you not subscribe to the oath under Article 99 and you are taking the part in the proceeding of the House, then you will be liable for the penalty of rupees 500 per day. And if you are disqualified or if you are not qualified to take part in the proceeding of the House, like AG, clear? They are not MP, right? He is not MP, but he can take part. Clear? So 500 penalty per day. In Article 105 about parliamentary privileges, there are two kind of privileges. One was Parliament as a whole, that means collective, and second was individual. Clear? Individual. So certain types of privileges, power, and immunities are available in the Constitution under Article 105. But if Parliament think to aid certain other privileges, power, then Parliament can make a law for that. Okay. Now I am always welcoming you to give your feedback in the comment section how I can improve the lecture for a good way, and I will like to read your suggestion as well. And if you like this initiative, why don't you subscribe to this channel and also like the video as well. So let's meet in next video.